Chair of the Disability National Development Working Group, and Gráinne Kilcullen, the Co-Chair of Humanitarian Aid Working Group, for organising this event and bringing together such an, I suppose, an esteemed group of speakers, which I think will enable a really fruitful and engaging discussion this afternoon. So with that, I'll hand over to Mahbub, I believe.
Thank you, Jenna. Good afternoon, everyone, and thank you for joining us today. I would like to begin by thanking Dóchas, the Humanitarian Aid Working Group, and all our speakers and contributors for bringing us together for this important discussion. As co-chair of Disability and International Development Working Group, alongside Lauren from Sciberras, Ireland, I'm particularly pleased to see the collaboration across Dóchas working groups that has made today's event possible. In many ways, this collaboration reflects exactly what this treaty process requires. The protection of people in disasters cannot be viewed through a single lens. Humanitarian action, disaster risk reduction, climate action, safeguarding human rights and disability inclusion are deeply interconnected. It is encouraging to see such a joined-up approach reflected in today's discussion. The proposed treaty on the protection of persons in the event of disasters presents an important opportunity to strengthen international cooperation and governance at a time when disasters are becoming more frequent and more complex. But it also raises an important question: voices shape our responses to disasters, and whose rights risk being overlooked. Climate change, environmental degradation, and conflict are contributing to increasingly severe and recurring disasters across the world. Yet, disasters are never experienced equally. A political ecological perspective, which is my favorite, reminds us that vulnerability is not simply the result of a hazard itself. It is shaped by existing social, economic, and political inequalities. Disasters expose and deepen those inequalities. Those who are already marginalized often face the greatest risks and the greatest barriers to recovery. It is particularly true for persons with disabilities, but also for older people, women and girls, displaced populations, and others who face exclusion from resources, services, and decision-making. Their vulnerability does not arise from who they are. It is often a result of systems and structures that leave some people more exposed and less protected than others. For me, this highlights one of the most significant gaps in the current draft treaty. The draft article rightly recognizes human dignity, human rights, and the needs of particularly vulnerable persons. However, they say very little about the meaningful participation of those same people in decisions that affect their lives. The treaty focuses largely on the responsibilities of states and international actors, but gives much less attention to the agency, leadership, and participation of people directly affected by disasters. This is an important missing piece of the human rights puzzle. Protection cannot simply mean making decisions on behalf of people. Effective protection requires participation. People affected by disasters must have an active role in identifying priorities, shaping responses, and determining what recovery and resilience should look like in their own communities. As the disability movement has long reminded us, nothing about us without us. The success of this treaty, and indeed the disaster governance more broadly, will depend not only on the protection it provides, but whether it enables the meaningful participation of those most affected. This treaty process offers an opportunity not only to strengthen legal protections, but also to set a new standard for inclusive governance. While negotiations are still underway, there is an opportunity to ensure that participation, accessibility, non-discrimination, and accountability are more clearly reflected in the final text. At CVM Global, and across disability movement more broadly, we know that when organizations of persons with disabilities and affected communities are meaningfully involved, outcomes are better. Responses are more effective, recovery is more sustainable, and rights are better protected. My hope is that today's discussion helps us identify how Irish civil society can contribute to strengthening this treaty so that it not only protects people in disasters, but also ensures that right to shape the decisions that affect their lives. Thank you, and I look forward to the discussion. Over to you, Chantal.
Thank you very much. I think Gráinne, invite Gráinne to say a couple of words.
Thanks, Chantal, and thanks, Mahbub and Jane Ann. I won't say any more, much more really to what Mahbub has said, but yeah, really welcome this space and discussion, and it's really important for us within the Humanitarian Action Working Group to have this broader discussion and for civil society to be more involved in this process. And I think we can all say that we are eager to see the progression of this treaty, given that it is offering a lot of possibility to enshrine disaster risk reduction into international law and ensuring that longer term accountability from states, and also just reinforcing those commitments under the Sendai framework and the other resolutions on disaster risk reduction. And I just want to echo as well what Mahbub was saying about the real challenge with the operational challenges, especially responding to the needs of vulnerable populations, and the plethora of challenges that happen, and including, you know, women and girls, and the risks of gender-based violence and the breakdown of services and community shelters, but also that the access to services for the wider range of vulnerable populations is really a very practical challenge on the ground. So yeah, we really welcome that. And I think I just wanted to re-emphasize as well, although, you know, the treaty is putting human dignity and it's reinforcing the centrality of human dignity, you know, upholding human rights in disaster risk reduction is also a really severe operational challenge. And I think just that we are able to bear that in mind throughout our discussion, as Mahbub said, to see how we can really try and influence, you know, that the upholding of human rights in a very a genuine way as well in disaster risk reduction. So yeah, looking forward to the conversation, and thank you again for hosting.
Thank you, Gráinne. So, yeah, I guess we can begin. We have Dr. Doug Cubie and Dr. Maria Aronsson-Storrier, who will be setting the scene, explaining us the background and context of this treaty and kind of developments thus far. Yeah, I hand over to Doug, I guess.
Excellent. Thank you very much, Chantal, and thank you, Jane Ann, and all the members of Dóchas. I think it's wonderful that we're having this engagement with civil society, with the organisations that are actually at the forefront of working in humanitarian assistance. Maybe just very briefly, I first heard of the concept of disaster law when I was working for the Irish Red Cross in the Indian Ocean tsunami operations. I never heard of anything like disaster law before when I was studying. And I've now been following this process for about 16 years. So I think it's really interesting how over the course of the development of what is now classified as the Convention on the Protection of Persons in the Event of Disasters, there has been very good engagement through the Red Cross, Red Crescent movement, but perhaps some of the other civil society organisations, it's gone under the radar slightly. So I'm really glad that we're having this session. I also want to apologise for anyone who has a detailed knowledge of this process. I may repeat some things that you know, and I'll try not to be too academic. But the way that Marie and I agreed that we'd split our 20 minutes or so is that I'll take 10 minutes to discuss some of the history and the process, and then Marie will take 10 minutes to discuss some of the substantive content. So hopefully between us, there'll be a bit of background. Some of this you may know, so apologies if it's repetition, but I think it's helpful for everyone to have a basis of where this process has started. As I say, it's been going on for 20 years at this point, which I think sometimes people are surprised about when they hear that. So without further ado, as I say, I'm going to talk a bit about the history. And surprisingly enough, we can actually go back 100 years to the first international law relating to disasters. So in 1927, we had the convention establishing the International Relief Union, which was developed under the League of Nations. And this actually stemmed from the 1908 Messina earthquake in Italy. I'm not going to be giving a full historical background, but I think it's quite interesting that the need for international cooperation between states in a legal framework has been recognised for a long time. Unfortunately, the International Relief Union itself, like many of the components of the League of Nations, wasn't actually very successful. It was intended to provide both research into disasters and humanitarian assistance. It continued post Second World War. Interestingly, it was only wound up in the 1960s, but there was a focus on human rights, genocide, refugees, understandably, after World War II, rather than disasters. If we jump forward, in 1982, we had the UNITAR model rules for disaster relief operations, which were non-binding and very much operationally focused. This was then followed in 1984 by the draft UN Convention on expediting the delivery of emergency assistance. And this very much took a technical approach, focusing on state sovereignty and how to facilitate international humanitarian assistance between states. There's very little focus on individual rights. And moreover, there was disagreements about the role of NGOs, and because of the Cold War, it died a death. So if we look at modern disaster law, the modern iteration, in 2000, the International Federation of Red Cross and Red Crescent Societies issued a call to develop an international disaster response law. This was recognised, but nothing really happened until the Indian Ocean tsunami. In 2004, the end of 2004, I'm sure many of you remember, it was such a complex international context, hundreds of thousands of people killed across 13 countries. And so this led in 2006 to the International Law Commission taking on board the topic protection of persons in the event of disasters. So the International Law Commission is the UN agency responsible for the codification and progressive development of international law. So in other words, it's the UN agency that discusses how we should advance new international law frameworks. So to give you an example, the Rome Statute of the International Criminal Court was originally developed by the International Law Commission. And the ILC, as it's known, is comprised of 20 independent experts who are often academics or former diplomats who are nominated by their governments. And in the original proposal in 2006, the UN Office for Legal Affairs tasked the International Law Commission with the elaboration of a set of provisions which would serve as a legal framework for the conduct of international disaster relief activities and clarify the core legal principles and concepts. So that was the request that was made by the UN to the experts in the International Law Commission. And so we can divide this into two different periods of time. We have the ILC draft articles process, and I'll explain what we mean by draft articles, which ran for effectively 10 years between 2006 and 2016. And then we have, if you like, the PPED period. So the time after the draft articles were concluded in 2016 up to today. And so if we look first of all at those 10 years when the International Law Commission was actively discussing and researching the topic of protection of persons. And a special rapporteur, Eduardo Valencia Ospina from Colombia, was appointed to lead the process. And he wrote 8 reports with colleagues and support covering different aspects, including definitions. What is the definition of a disaster? Marie's written an entire book around that. So these are areas which are very complex. He was also looking at issues such as international cooperation. is this a process which should be focusing on response, or is it also looking at risk reduction? So the 8 reports, there's a huge amount of information that's taken place and is publicly available in terms of how the current PPED text was developed. And during those 10 years, each of the time that Eduardo developed a report or developed a proposal for a draft article, there was deliberations between the 20 members of the International Law Commission. And then there was also input from governments, from states, in the UN General Assembly 6th Committee. And the 6th Committee meets in New York and is classified as the legal committee. So, for example, Ireland, the Department of Foreign Affairs, has at various points made their inputs into the draft articles process through comments that they made in the General Assembly 6th Committee. This ended in 2016 with the agreement by the International Law Commission of a set of draft articles. There's 18 of them, and they look like an international treaty. And many of you maybe have already looked at these. So this was condensed down from 21 articles originally. So as part of those original negotiations, there was condensing and changing that took place till we end up with what is classified as the draft articles on the protection of persons in the event of disasters. And the International Law Commission also produced detailed commentaries on each of those 18 articles, explaining their thinking as to why they've worded it a particular way, or the key sources that they've relied on in developing that language. Interestingly, the original proposal in 2006 was entitled International Disaster Relief Law, but the International Law Commission itself decided to change the title to Protection of Persons in the Event of Disasters. And I think this is quite an important distinction. And Mahbub has also already highlighted this need to focus on the rights of the individuals who are affected. However, the commentaries to the draft articles clearly state that the main focus of the draft articles are the rights and obligations of states in relation to one another. So one of the key points for discussion in relation to the future treaty is the emphasis on improving the efficiency of interstate relations during a disaster. So allowing for expedited delivery of relief goods and assistance. So if you like, a technical agreement, which is our technical treaty about how states can work together. We can think of this as a horizontal axis of cooperation between states. Or is the emphasis on the individual rights and state responsibilities that arise towards individuals, so a vertical axis between states and individuals affected by disasters? Just briefly, and I'm conscious of time, I don't want to take Marie's time, there was a brief hiatus between 2016 and 2020. And to be honest, at that point, we weren't sure if anything was going to happen to the draft articles. Were they going to be put on a shelf and forgotten about? But then COVID, along with the climate crisis and the increasing awareness of the climate crisis, reinvigorated the process. And there was a range of countries, including the Bahamas, Colombia, Croatia, Italy, Jamaica, Thailand, and the Philippines, who were very much behind this process and pushing to move from the draft articles to an actual international treaty. And obviously colleagues from the Red Cross, Red Crescent movement as well. So very briefly, in November 2024, the 6th Committee, the Legal Committee, agreed that they would conclude a legally binding instrument on the protection of persons in the event of disasters by the end of 2027 at the latest. The General Assembly then invited governments to submit their comments by the end of 2025, so December 2025. And in April of this year, the 6th Committee established a working group on the protection of persons in the event of disasters to prepare a consolidated text. And the final government submissions were made by the 15th of May of this year. We're next going to have a preparatory meeting, so an advance meeting in advance of a conference to negotiate the treaty on the 31st of August to 4th of September of this year, so in about a month's time. There's then going to be an international conference held at the end of January to into February in 2027, and potentially then another 2 weeks in August. This conference was originally intended to take place in Manila, but the Philippines have recently pulled out of hosting the conference, so it's likely to take place in New York instead. So I'm just going to conclude by highlighting 4 areas that I think are important, and Marie will develop these, I'm sure. So the first is the question, do we want a binding international law treaty or a non-binding text like the Sendai framework? We need to think of state sovereignty. What are the rights of the affected states compared to donor states? As well as then thinking about who are the relevant actors, states, intergovernmental organizations, and non-governmental organizations. And the final point I'd just like to make is this tension between, is this a process to focus on individual rights, or is this a technical and operational treaty between states to facilitate international humanitarian assistance? I'll finish there, and obviously happy to take questions and comments later on, but I'll hand over to my colleague Marie now. Thanks.
Thank you, Doug, and thank you for that excellent background and overview, and to set this up so nicely there at the end. So hi everyone. First of all, thank you so much to Chantal and Mahbub and the rest of the team for organizing, and to everyone joining us here today. It's really great to be here. As Doug mentioned, I've been asked to provide a general overview of the text, the proposed negotiation text for the convention. I should say, in some of the key tensions, and the key tension that Doug just mentioned at the end there, being that of the state sovereignty and this interstate relations versus the focus on the protection of persons. And I'm sure that other speakers will comment well into that a bit more later as well. I should say that the text that we're discussing here is still the same as the ILC draft articles adopted on second reading in 2016. And work is underway to produce an updated draft text in response to comments provided by states. So the text being discussed at the diplomatic conference will likely look a little different, but this will still help as hopefully serve as a helpful starting point for now. So if you're not familiar with the text, if you are familiar with the text, you're gonna recognize a lot what I'm saying, but I think it's helpful just to go through it. We currently have 18 articles. There's also a preamble, which I will skip today in the interest of time. So I will keep things very brief for now, and I think we can then go deeper into various aspects in the discussion later on. So just going to jump straight into it. Starting with Articles 1 and 2, they set out the scope and the purpose, and these articles should importantly be read together. And although the scope in Article 1 refers to the protection of persons in the event of disasters, the commentary clarifies that while the primary focus is on the immediate post-disaster response phase, early recovery, it also includes disaster risk reduction, so prevention and mitigation activities, as clarified in Article 2. Now, I've said this before, and I will say it again, that it would be very beneficial to update the wording to clarify that the scope includes disaster risk reduction and recovery in line with the commentaries. And indeed, this is one significant challenge with these negotiations that we've seen, is that while the draft articles benefit from ILC's extensive commentaries for additional details and clarifications, if you haven't seen the commentaries, they're incredibly detailed, they're very helpful. This is not the case for a convention. So there needs to be very careful consideration given as to what aspects of the commentaries should be incorporated into the main text. Article 3 then sets out the use of terms. And the most discussed, I'm not going to go through all of them, don't worry, but the most discussed term there is the definition of disasters, as currently set out in draft Article 3A. Disaster is there defined as a calamitous event or series of events resulting in widespread loss of life, great human suffering and distress, mass displacement, or large-scale material or environmental damage, thereby seriously disrupting the functioning of society. Now, it's a lot going on there. We're not going to have time to unpack it, but we can discuss later. There have been plenty of suggestions here for changes to this definition. And for example, I wanted to highlight that a number of states have suggested that we instead use the wording provided by the UN Office for Disaster Risk Reduction, which is more in line with contemporary understandings of disasters, which moves more to the creation of disasters, the building blocks of disasters, and also includes reference to disruption to the functioning of communities as well as societies, as the very word society and the lack of the definition thereof has created quite some concern among states since the very early days of the ILC draft articles. Of interest for many of you here today will also be Article 3D, which defines other assisting actor. And this is defined as a competent intergovernmental organization or a relevant non-governmental organization or entity providing assistance to an affected state with its consent. So that is the way in which other assisting actor is used throughout the text. Moving on then to human dignity and human rights. Articles 4 and 5 call for the respect for and protection of the inherent dignity of the human person and of human rights in accordance with international law. Article 6 then clarifies that the response to disaster shall take place in accordance with the, to many of you, familiar principles of humanity, neutrality and impartiality, and on the basis of non-discrimination, also while taking into account the needs of the particularly vulnerable. Others will speak more to these articles shortly, including operational challenges, which are significant, which has already been mentioned. So I will not say much now, but it is worth noting that Articles 4 to 6 have received comparatively little attention, with a few states suggesting that some additions to Articles 5 and 6, with only a couple of states, though importantly Ireland included, have called for them to be moved to the preamble. We then now turn to the important issue of cooperation. Article 7 sets out the obligations for the duty for states to cooperate amongst themselves, but also with the UN, with the components of the Red Cross and Red Crescent movement, and with other assisting actors. Now, the duty to cooperate, in particular as it concerns cooperation among states, it's a well-established principle of international law, and one which is of central importance, of course, in international disaster relief assistance activities, but also in the reduction of disaster risk. Specific forms of cooperation in the context of the response phase are covered later than in Article 8, whereas cooperation in the pre-disaster phase, including disaster prevention, preparedness, mitigation, is dealt with in Article 9. So it's important to note that Article 7 is an all-encompassing duty to cooperate. Doug mentioned that the scope of the draft article changed a little bit as they moved along, and it was very focused, and it has been, still remains quite focused on relief. But ultimately, disaster risk reduction made its way back into the draft articles, and draft Article 9 is the clearest example of this, and states that each state shall reduce the risk of disasters by taking appropriate measures, including through legislation and regulation, to prevent, mitigate, and prepare for disasters. And they also, the second paragraph would list a non-exhaustive list there of such activities that can take place. It's important to note that this is an obligation of each and every state, but it's also an obligation of a duty of action, not a duty of result. This is also, I should note, the end of any mentioning of disaster risk reduction in the draft articles, with the rest of it focusing on response. So moving on then to the very central Article 10, which establishes that the affected state has the duty to ensure the protection of persons and provision of disaster relief assistance in its territory or in its territory under jurisdiction of control. So it is for the affected state itself to lead the direction, control, and coordination and supervision of relief assistance. So the role, this is the primary role for the affected state here. And as you can imagine, that can also lead to specific operational challenges, in particular when there has been a really significant disruption to the functioning of that state. This then is followed by Articles 11 to 13 that cover the duty to seek external assistance, offers of assistance, and the importance of consent to assistance. So here we're coming into real tensions around sovereignty and questions around sovereignty and non-intervention. There have been a lot of questions around whether there is a duty to seek assistance or a duty to offer assistance, where there's a right to seek assistance or a right to offer assistance. So this will likely come up again, but currently there is the text as is currently is a duty to seek external assistance, and stating also that offers may be made and that they may not be rejected arbitrarily, although that states need to consent for any assistance on their territory. So just finishing off with the articles towards the end, which will be interest of anyone involved in humanitarian assistance. Article 14 establishes the right for the affected states to place conditions on the provision of external assistance, with Article 15, importantly for those of us who are interested in law, highlighting the importance of legal preparedness. And it requires then the affected states to take the necessary measures within national law to facilitate prompt and effective provision of external assistance, with then Article 16 continuing going into the appropriate measures that need to be taken in terms of relief personnel and equipment and so forth. Again, no particular concern raised here, but there have been some suggestions, interesting suggestions here to elaborate and actually add some lists here, either in the form of additional articles or even in the form of an added annex. The final article focusing on assistance is Article 17, which focuses on termination. So either the affected states or any assisting actor has the right to unilaterally terminate external assistance at any time, but this must be done with appropriate notification and consultation with other actors. And also, and this is where the commentaries are really important, we have to see if they make their way into the text, is that they highlight there that the decisions regarding termination should not adversely impact affected persons. There is then a final article which focusing on the relationship to other rules of international law. And this has been brought, and in particular, the concern here has been a clash between international disaster law and international humanitarian law. So the text does not, is without prejudice to any other applicable rules of international law and does not apply to the extent that the response to disaster is governed by the law of armed conflict. But this also means, even if it's primarily discussed in relation to IHL, this also means that it's not, it's completely without prejudice to, for example, any international human rights law as well. And I think we have so much to discuss today, so I'll leave it there. Thank you for listening, and I look forward to the discussion.
Thank you, Marie and Doug, for such a useful presentation. I'm still absorbing it. And I have a few questions for later, but I'll let others speak. Thank you very much. I will move on quickly to the disability inclusion perspective, and I invite Juliet Mwema to speak, and then Gordon will follow. Thank you. Don't have to unmute her. You're muted, Juliet.
You're muted, Juliet.
Hold on. Perfect.
Can you hear me?
Yes. Thanks, Juliet.
My apologies for that.
No worries.
Thank you very much for having me. As a woman with disability and representing an organization of persons with disability, I am extremely grateful for this very timely conversation. Allow me to start with a simple truth. When disaster strikes, it does not strike everyone equally. And right now, I feel like this is a truth that has not been captured very clearly in this treaty when it comes to disability. I work with women and girls with disabilities in Kibera, which is one of the largest informal settlements in Nairobi in the Global South. And I have seen what happens when, for example, flooding hits, and it hits every season. I have seen what happens to a woman with mobility disability facing an inaccessible evacuation route because no one thought about accessibility in the events of evacuating a woman with mobility disability. I have seen shelters that do not have ramps, which ideally makes them inaccessible. I have seen long relief queues, which basically assume that everybody can queue for a long time or stand for a long time. Information campaigns that technically leave out women or persons who are deaf, because no one remembered to factor in sign language interpretation. Another very important factor I feel that is often left behind when it comes to disaster response is assistive devices and equipment. Think about a wheelchair that is left behind during flooding, a hearing aid, or a white cane damaged in a chaotic evacuation. Another very important factor is the lack of data when it comes to counting for persons with disabilities. And it is very hard to plan for a person with disabilities if they are not accounted for. Another very important point is the intersectionality of gender and disability. A woman with disability and a caregiver in the events of disaster face a heightened risk of violence and being left behind because of this intersectionality. And I feel like this is this needs to be reflected in this treaty. And my core asks is very simple. Include disability as a general principle. And what do I mean by this? I mean, let's have disaster inclusive early warning response systems that are designed with and not for persons with disabilities. I'm thinking about accessible shelters that have ramps and relief queues that are considered persons who are not able to queue for long. I'm also thinking about sign language interpretation when it comes to information and communication. One other core ask I will have is the data and disaggregated data that counts persons with disabilities right before disaster happens, so that we're able to plan for them as a basic requirement and not as an afterthought. Another ask is inclusion of persons with invisible disabilities like psychosocial disabilities, because in often cases they are not factored in or even remembered. The involvement of persons with disabilities from the affected communities, talking into the framework, because they are the ones affected the most when it comes to disaster. And I'll conclude by simply saying that inclusion of disability and the intersectionality of gender in this treaty is very important, because it reflects the experiences that we face when disaster occurs, especially in the informal settlements in the global south. And my last statement is nothing about us without us. And thank you very much for listening to me.
Thank you, Juliet. Short, but very, very effective. Well done.
Thank you.
I'll move to Gordon now.
Thank you very much, colleagues. Can I just check first that you can see the slide that I'm sharing?
Yes, we can.
Perfect. Okay. I think Juliet has done an excellent job of setting the scene regarding disability inclusion, and also pointing out some of the key gaps that we already have seen in the articles, and that must be included in the final convention if we are to make sure that persons with disabilities are going to be reached and involved. What I want to do is take a few minutes to talk about the advocacy work that we've been doing at global level. So this has been led by the Thematic Group on Disaster Risk Reduction and Climate Action, as well as the Disability Inclusive Disaster Risk Reduction Network. You don't need to remember the names of these networks, but they are representative of more than 400 people. More than half are members of organizations of persons with disabilities. And we are working for the inclusion of people with disabilities in the implementation of the Sendai framework, and all of the work that goes around it. I'll move to the slide now. The work that we have been doing on this treaty started last year. So we did an analysis of the draft articles. We developed a policy brief which goes through the articles one by one. It's a 6-page document, and I'll try to drop it in the chat here after I speak. And it points out with each article what are the key points for that we think should be changed to ensure disability inclusion. And at the end of the year, we reached out to states and others who were involved in making submissions before the December deadline. And the result, I'll talk about it in the next slide, about the results that we had from that. This year in July, we're now at the stage of developing more specific talking points, also an advocacy toolkit that civil society can use leading up to the meetings that are coming at the end of this year and the beginning of next year, and reaching out to states and others with these documents. So this slide just gives a screenshot. I'm not expecting you to read the text on the slide, but basically it gives an example of what we have in the advocacy document. So for example, we require inclusive planning and participation, and this is relevant to Articles 5 and 6, and we've put in suggested text here. So the point here for policymakers is that our advocacy document is meant to be relevant, easy to use, and very practical, because it relates directly to the articles that exist and what we think need to be changed. Again, no need to try to read what's on the slide. I just wanted to make clear that the advocacy brief should be a useful tool moving forward. What we've seen from the current texts is that there were 45 submissions from member states received by June this year. A compilation document was developed, and there will be a new one, as far as we're aware, before the next PrepCom meeting. And at this point, there are only 4 references to disability in all of these submissions, which is pretty disappointing, to be honest. We've seen from Costa Rica, Malaysia, the Philippines, and Germany. As far as we're aware, there's no other state which has explicitly referenced disability, which means that when it comes to development of the policy, disability will be forgotten. We have developed 4 key talking points. I'm not going to read the slides, but the first one is to ensure accessibility through all disaster preparedness and response measures. And then there are the details of where accessibility should be included. I hope we can share these slides with colleagues after the event so you can have all of the details. The second one is the meaningful participation of persons with disabilities through their representative organizations, so OPDs. And this talking point will actually be slightly altered to say not only the participation, but the leadership of OPDs, the leadership of persons with disabilities and their organizations. The third of the 4 is to ensure that budget is developed in a way that accessibility and reasonable accommodation can be provided at the time that the policy requires it. What we often see is that policy is in place and there is goodwill to implement the policy, but then there's no budget. So budget must be there in the first place. And the last point is to ensure data disaggregation on disability, gender, and age. If there's not explicit reference to disability, then again, it will be forgotten when it comes to policy implementation. And my last slide is just to give you an idea of the advocacy work that we're doing. So we're producing key messages. We're doing this in different formats for accessibility. We're gathering case studies to show the importance of disability inclusion. And there will be, in the coming weeks and months, an advocacy campaign on social media and sending information to states to ensure that they have the information required to include persons with disabilities in this work. I'll stop there. I hope that was useful, and I'm here for any questions that you might have. I'll try to drop the policy brief in the chat. If it doesn't work, then we can send it afterwards.
Thank you very much, Gordon. That was really useful. And it's a very practical way of kind of putting forward your points on advocacy. I'm going now I pass on to Sarah West, colleague, quite familiar face for many of us. She will give an overview of the Red Cross and Red Crescent works on the PPED. Thanks, Sarah. And thanks, Gordon, again.
Thanks, Chantal. Are you seeing my screen? You are, yeah. Great, thanks. Super. So hi, everyone. I think, yeah, certainly some familiar faces, but for those who don't know me, my name's Sarah West. I'm the Humanitarian Law and Advocacy Coordinator with the Irish Red Cross. And I'm going to be brief. I want to sort of focus, I suppose, on what the International Red Cross and Red Crescent movement see with the PPED, with the protection of persons in the event of disasters, and the work we've been doing on this. And many colleagues have been working on this for as long as it's really existed. So I'll just sort of highlight some of that and why this is such a key opportunity for those of us in the sector here in Ireland. So the PPED matters because at the end of the day, I suppose we're seeing, and all of us here know very well, that the prevalence of disasters is increasing. And 2024, we had 150 large-scale disasters recorded with 146 million people affected. So that was an 11% increase on the average over the past 5 years. And most of those were weather-related, so disasters like floods and hurricanes. And, you know, as humanitarians, we all know the amount of effort and time in responding to the consequences of disasters. And we know that people in vulnerable situations are disproportionately affected. And I think Juliet highlighted that very well. The impacts aren't felt the same by everyone. And in fact, disasters can expose and worsen existing vulnerabilities and inequalities. And so, you know, when we talk about protection, it's not only about saving lives in disaster, but it's also about preserving human dignity, you know, ensuring access to shelter, to healthcare, information, family unity. So that's one side, I suppose, of the treaty, and the other side is around, I suppose, addressing regulatory barriers that can delay and complicate responses. And, you know, for example, many of you will remember the earthquake in Nepal in 2015. I remember being there working with a different organization at the time, and we had relief goods that were stuck at the airport over sort of questions around customs and taxation. And in fact, we drove past the airport at the time, and there were pallets stacked sky high of relief aid that was stuck at the airport and delayed the response. And then even once, you know, assistance is accepted, there can be, you know, a lack of clear coordination and procedures that can create confusion and duplication. And indeed in Nepal, I remember visiting some villages who said, you know, you're the fifth ones here, you know, in the last 2 days, and other villages who had yet to receive any aid. So, you know, that kind of gap in coordination and cooperation can lead to really uneven or inefficient responses to disasters. So that's why the PPED is so important, I suppose. It closes that gap and makes sure that we have this international agreed standard in a way, and kind of harmonized procedure for how we conduct disaster risk management and response. So a bit about the Red Cross, Red Crescent movement and our involvement, and I think Doug mentioned it. You know, the movement has been involved in disaster law really since the response to the tsunami in 2004. And essentially, we have a mandate both to conduct research and advocacy on disaster law and sort of share some of the learnings that the movement have in responding to disasters, and to assist states in developing and strengthening their own disaster laws in their own national legislation. So over the last 20 years or so, the IFRC, the International Federation of the Red Cross, as well as the national societies, have provided technical support to over 95 governments in shaping their own national disaster law. So the Federation in particular, the IFRC, have been involved, in developing IDRL guidelines, which actually influenced the draft articles of the treaty that you see today. And so, yeah, that's just to sort of highlight that I suppose we've been working on this for a while, and we have a team of colleagues who have worked really hard to try and make this treaty quite accessible. So there is a dedicated webpage that I'll share after this with a lot of resources that are helpful to understand what the PPED is all about. They have some really useful fact sheets and submissions, and they also have some case studies about disasters and the response to them, and sort of, yeah, why we need the PPED. So I suppose just highlighting some key objectives from a Red Cross, Red Crescent movement point of view, and apologies if some of these are very Red Cross centric, but I suppose really drawing your attention to the first three there. You know, the priority is to prioritize disaster risk reduction across all sectors before, during, and after disasters. So as I think Marie mentioned, the new treaty is expected to establish a duty for disaster reduction, and that would drive forward domestic efforts to reduce disaster risk and create legal incentives for states to invest in disaster risk reduction and embed those responsibilities across all sectors and encourage stronger cooperation in that regard. So it's a really key opportunity on that. And then, as many mentioned, the huge opportunity with this treaty is that it can ensure that all people that are protected in disasters, and especially those in vulnerable situations. And that's why it's called protection of persons in the event of disasters, right? It's more than just a coordination treaty. It's about making sure that the needs of people, especially those in vulnerable situations, are taken into account and that their human dignity and indeed their human rights are protected. And it also means that disaster response is in accordance with humanitarian principles. So the ones we're very familiar with of humanity, neutrality, impartiality, that is what we apply when we're responding to disasters. Thirdly, then, the treaty needs to address the facilitation for fast, effective, and coordinated humanitarian assistance. So it'll define cooperation mechanisms in disasters and require affected states to adopt all measures to save lives and to ensure prompt and effective delivery of international humanitarian assistance, and to make sure cooperation not only between states, but also states and other assisting actors. And then the last two objectives are, I suppose, that's where you get into the Red Cross centric objectives that we have to sort of recognize the auxiliary status that the national societies of the Red Cross have. So we're not an NGO, and we're not public authorities. We're auxiliary to public authorities in the humanitarian field, and to provide a role for the IFRC, the Federation, as well. So really, I suppose the point of the webinar today is to make the sector aware of the opportunity that this presents. And I suppose it's not very often that an international treaty is being agreed, and that we have the opportunity to make sure that how we respond to disasters is, you know, as impactful as possible, and that we make sure that our response is led by, you know, human rights and led by the people who we're serving. So as a sector, you know, as humanitarian and development organizations, this is going to impact our work. It's going to impact the delivery of support and how we respond to disasters internationally, but also nationally for those of us who work on disaster response here in Ireland as well. And so because of that, because it's both sort of domestic and international, it's quite a far-reaching and cross-cutting area. And so there's an impact for work here in Ireland and internationally. And so we need to make sure in a way that it doesn't fall between two stools, right? That it's not something that only domestic authorities are aware of, but something that actually those of us who deliver international aid are aware of as well, because it will impact our work. And we need to make sure that what we know in terms of responding to disasters is captured within the treaty, right? The lessons that we know, the fact that we know that people in vulnerable situations are impacted disproportionately, that needs to be reflected in the treaty. So I know in the current climate, there's a lot going on for everyone, and, you know, especially with the EU presidency over the next 6 months. But I suppose the time is now if you want to engage on the PPED, and the time for influencing is now, with the PrepCom coming up in September, as Doug said, and then the diplomatic conference in January. So I'll share with you in the chat some of the resources that the Red Cross have developed, but I have my email there on the slides as well. If anyone wants to get in touch, we'd be more than happy to engage and share more information if there's interest. Okay, I'll leave it there and leave some time for questions. Thanks, everyone.
Thank you, Sarah. Thank you very much for that, actually. Really well done. Before I go on and ask a few of my questions, I want to open the floor to questions or some reflections on that anyone may have on what we've heard from our speakers today and also on the treaty. It's going to be the brave first one. No one? Ruben?
Oh, yeah, I'll break the ice.
Thanks.
It's been a fascinating last hour to listen to all. I haven't read the draft articles, so for me, the introduction, Doug, you gave was really helpful, and to have the whole briefing of the piece. Perhaps my question is a practical one, given that TROCRA, who I work for, is an international organisation, and most of we do programming is focused on the Global South generally. And so actually I'm interested to know that the inclusion of disaster risk reduction and preparedness is incredible to see, but I'm just interested to hear, are there divisions between the Global South and the North on sovereignty, on even just the disaster and the response section of it, and to what extent including preparedness, moving or expanding the scope seems to be a big step up, and especially when, as I know it was introduced by Mahbub of CBM, trying to put persons, particularly the vulnerable people, persons with disability, front and centre. Just interested to know to what extent is there space and interest from the global communities, the states, to have these included in the treaty, and do they add sufficient, or what level of value add do they bring? Thanks.
I think Maria wants to respond.
Happy to jump in. Thank you so much. That's a really excellent question, and one that I certainly have been considering for quite a number of years now and following closely. So in terms of there's no clear division that you can see between sort of so-called global North, global South in terms of incorporation of disaster risk reduction. There are a very, very vast majority of states now are strongly in favor of incorporating DRR, which has been great to see. And that has followed also, I think, not just the development of Sendai framework, but we've seen a really significant increase in terms of national DRR laws and strategies since 2015. They have more than doubled. So we are, I think, over 130 countries now have national DRR strategies. So you've sort of taken the heat out of that quite a lot. There are a number of states. More interestingly, France was the last one to actually suggest that DRR should be removed, which was interesting. That came just a few months ago. But otherwise, what we've seen, of course, there is a stronger, perhaps, certain countries that are more affected by climate change, who might be sort of pushing the climate resilience aspects a bit more, whereas others are pushing back against that. So I think the word climate is unlikely to make it in there, which is perhaps not surprising, although one might question it. In terms of, but I do think there's a very good chance that the DRR would make it in, but you're not going to find consensus on it. It's only a handful of countries now who don't want it in, and there are a small number of countries who would like it to be a should instead of a shall, so a softer obligation to reduce disaster risk. But most countries very, very strongly are in favor, and that has been really, really significant. And that is a lot of the work, I think, from everyone in the DRR space that have pushed that and successfully. So especially since the COVID years, we've seen that. Thank you.
Doug?
I think Doug might have.
Yeah.
Yeah, thanks. Just to follow on, because Ruben, thank you. I agree. Your question's so pertinent. And to pick up on your question about sovereignty, as you can perhaps imagine, there's various countries who have presented a stronger argument in terms of sovereignty and state control over the international assistance that may arise. And one of the tensions, and understandable tensions, is the recognition that the affected state has the primary responsibility to respond, to prepare and provide protection for persons affected. You know, that goes back to many General Assembly resolutions. The question is, what do you do in situations if we think of Cyclone Nargis in Myanmar, where you have a state which potentially doesn't want to accept international assistance. Marie mentioned one of the most contentious parts has been around this question of arbitrarily refusing. What does it mean for a state to say, actually, we don't want to accept that assistance? And there may be good reasons. I mean, it may be food that's being provided which isn't culturally or religiously sensitive. Or we all know, unfortunately, the bad stories of aid that's being provided which is out-of-date medicines or so on. So how does a state that is affected by a major disaster control the assistance that's coming in? But at the same time, how do we ensure that that's not going to be a closed border, we don't need your help, even though they clearly do? So that arbitrarily refusing, I think, is something that we're definitely going to see more discussion of, because that really gets to the heart of that question of sovereignty. What control does an affected state have? Or can a donor state or a donor organization push ahead to provide assistance without the consent of the affected state? That's a very contentious question. Thanks.
Thanks, Doug. May I have a little question kind of based on this? And also from an advocacy perspective, what do you see are what are countries the ones who are putting challenges forward on DRR and even softening languages? What are the pretexts or I'm not sure about the word I should use, the pretext they are using? What's the reasoning or the justification for what is the big issue besides climate? Because climate, I know, has been a bone of contention for a long time in negotiations of any kind. Yeah.
So they basically, and interestingly, one of the main arguments is that there are two main kind of strands. One is that it just loses the focus, and we should be focusing on response, otherwise you lose the focus and it becomes too broad and it's too much. And that perhaps is the more convincing one, where I can see them actually getting the attention and potentially agreement from other states. And then there are others that are just simply saying this was by the International Law Commission bringing this in was a very obvious example of progressive development of international law. It was not codification. It doesn't exist. So therefore we shouldn't have that doesn't exist in international law, and it would create undue burden on states to do this. Now that is no longer a very convincing argument, or considered by most to be a very convincing argument, and that's where we're really seeing a change, I think, especially when you do have the state practice of having national strategies and legislation. But those are the key ones to simplify.
Thank you very much, Marie. I have more questions, but I'll wait. I'll give room to others to ask. Anyone else? Gráinne?
Hi, thanks very much. This has been really, really interesting. I just wanted to ask a small question. Well, just a question about that tension between the kind of spirit of the treaty, whether it's really in relation to states coordinating that technical response versus the responsibilities of states to individuals, and kind of that more human rights-based focus. And I suppose, and excuse me if this is kind of too simple a question, but why could it not be both? Or why is there, what is the actual tension there? I'd just like to kind of better understand, given that there is kind of clearly those articles there on human dignity, human rights, but equally the other articles dealing with how states can cooperate and respond. So yeah, just be interested to know that thoughts on that.
Anyone wants to go? Marie, Doug?
I can try. I think there's two ways you can look at it. The first is a positive way of saying, well, actually, we already have international human rights law. We have provisions in international humanitarian law. So if we think about Articles 4, 5, and 6, so Article 4, human dignity, Article 5, human rights, and Article 6, humanitarian principles, they're already well established in international law. I'm conscious there's representatives from Foreign Affairs on this, but the Irish government has proposed moving those articles to the preamble. So taking them out of the operative articles to say, well, actually, this is the background, if you like, to the treaty. And that's in recognition that human rights apply in a disaster context. Your rights don't disappear just because there's been an earthquake. So there's an argument to say, well, actually, we're just repeating things, and potentially we might even end up in a situation where something is lost in translation because we've got a conflict between two bodies of law. So that's one way of looking at it. You could perhaps put a more negative slant on it. Unfortunately, human rights law at the moment is facing global challenges in terms of the respect of rights of individuals. There's states, groups who are very keen to reduce people's rights, and therefore they would be keen to take these provisions out for other reasons. And so therefore, if we're focusing it on the rights of states, okay, what can states do? So that's not just about individuals, but it's also about the humanitarian actors. So there's an argument to some states may say, well, we want this to be about how states can interact with each other. There's obviously then the argument to say, well, we already have human rights law in place. Let's not complicate things, because what we're really looking at is how, for example, Gordon mentioned Article 11 of the Convention on the Rights of Persons with Disabilities. That already refers to the rights of persons with disabilities in humanitarian crises. So let's not complicate matters. So if you like, there's a positive spin and a negative spin you could put on it.
Yeah, thanks, Doug. And yeah, I suppose I was just really thinking about what Juliet was saying as well, and how often, the rights of people with disabilities and those who are facing intersectional vulnerabilities are forgotten. And I know, and I, the disability movement have worked so hard to move away from, assistance and support and being given things to a really rights-based approach. So I suppose, I just, hopefully we can, I guess I was just trying to air that kind of concern as well, on how important it always is to reinforce that commitment. But yeah.
Thank you, Gráinne. I'm very conscious of time. We only have 2 minutes. Before we conclude, I don't have much to add. I just have a question on what happened. 2 questions, and it will be really just to conclude and finalize. And I would love to see responses as well from Gordon and Juliet. On the legal perspective, how will this treaty be operationalized? Will it be binding? How will member states, are these provisions, or what is being foreseen? I know it is the most difficult part of any treaty, from my understanding. I'd be interested to know how will states be held accountable eventually, or what is being conceived. And finally, especially Gordon and Juliet, how can civil society better engage, and what are the spaces available for civil society to engage in this process, into the final negotiation? Did you want to say something else, Gráinne, or do you have a legacy hand there?
Sorry, legacy hand. Sorry.
Okay, good. Gordon, do you want to speak? Sorry, hand
Yeah.
earlier.
Yeah, thanks very much. Actually, I was actually going to respond to your first point. For us as the disability community, the Sendai framework is an excellent document, very disability inclusive, and it is so because we were able to participate completely in the development of the Sendai framework. However, it is not legally binding, so really it can potentially have no impact at all. And that's why the PPED, if it is legally binding, would be, and if it follows the accessibility and all of society and inclusive approach of the Sendai framework, would be a hugely beneficial tool for not just disability inclusion, but inclusion of all marginalized groups, and for the benefit of everyone in society. So from our perspective, it would be massively beneficial if the PPED is legally binding, and for civil society space to engage in this. Well, it's at local, national, and international level. It's about making space for the OPDs, the representative organisations of persons with disabilities, to be part of the decision-making processes. So the duty bearers, the states, the governments are the ones responsible for making this space for civil society. The CRPD requests this of them, and we expect it. That's my take on those 2 points.
Thank you, Gordon. Marie?
Yeah, just to add there, thank you also, Gordon. Yeah, excellent point. And I agree that the Sendai and the UNDRR process is just light years ahead in terms of inclusivity, although a lot can be done there too, of course. So in terms of civil society engagement at the conference, that detail is to be decided at the preparatory conference, but there is already has been decided that accredited organizations will be able to attend. So that is already established through the ECOSOC framework. But then you also have, interestingly, in terms of the accountability, there have been some discussions, and I know Italy, for example, have suggested a conference of the parties. So sort of a COP for the things. I think it was Portugal that suggested a sort of meeting of the state parties, which might be, but a conference of the parties, as we have seen with other COPs, could potentially also then actually, depending on how it's framed, involve civil society in terms of working towards implementation. But those have, again, we are waiting. There has not been a lot of discussion, and that is one that is certainly many of us are looking closely at, because that is, of course, going to determine a lot. Even if it's the binding, that's really going to shape this for the next few years or decades, certainly.
Thank you, Marie. I wish to close. Sarah, please.
Sorry, I snuck in at the very end there,
Right.
Chantal. Just very briefly, yeah, just to add as well, I suppose that in a sense here in Ireland, we're very lucky in the sense that we have Dóchas, we have all our working groups within the sector. I think we're quite well organised and engaged. And then we also are lucky enough to have, some leading experts on this area here in Ireland in UCC, in Doug and Marie. So I suppose do engage through Dóchas and I suppose make use of the expertise that's here in Ireland. And yeah, I suppose let's kind of work together on this. We can engage together as a Dóchas network on the PPED. Thanks.
Thanks, Sarah. That's exactly what I wanted to say. I don't have much to add besides what Sarah said. I think we're all in unison. I think thank you everyone for this. It was really informative. I learned a lot. I hope everyone learned. Thanks you. I'm seeing Rachel from DFA. Thank you for coming. Wish you all the best. You must be very, very busy right now. And all colleagues from DFA for attending. I hope it was useful, and maybe we can take this forward in a discussion at some point, because that helps. Thank you very much, everyone, and I'll leave you to go enjoy your lunch.
Thanks very much.
Thank you, everyone.
Thanks.
Thank you.
Nice to see you all.
Thank you.
Bye.